What does a win look like, Mike? I mean, there's a philosophical issue here. There's also the literal, you know, damages and how they get paid. You know, for your client or somebody, I think I've heard you say you felt like the Aaron Brockovich of the opioid crisis at one point, because I know that you were at times a lone voice. What is an optimal outcome that's realistic?
Yeah, so I think it's accountability to hold individuals accountable, because otherwise this is just a roadmap for future mass tort crimes, you know. And secondly, we don't disagree. The resources should be distributed to the individuals that were harmed in these cases. So we're certainly not against a financial resolution. And I could be very nitpicky about particular parts of the plan. We're not really focusing on that. What we're focusing on right now is doing away with these third-party non-debtor releases, because it just incentivizes business owners and decision makers to act recklessly, because they'll always have an escape hatch. You know, they'll always be able to throw the entity into bankruptcy and piggyback right along with it and limit their liability in a very proactive way. We don't think that that's just, and we don't think that that's what the bankruptcy system was set up to do.
Help me look around the corner a little bit, because I think obviously this is not what the bankruptcy, you know, courts were initially designed to do. Given what you know about the Supreme Court, whether through, you know, doing amicus briefs or anything else, let's say that this is struck down. What then? Did we go back to the drawing board? Or in your experience, what would be some of the alternatives besides accountability? What does the next deal possibly look like if bankruptcy court's not an option?
Well, we certainly hope that, you know, the Solicitor General is taking on this case. We hope that it emboldens the Department of Justice and they do pursue criminal charges for individuals if this is overturned. Secondly, we think that this is just the first layer of a series of negotiations that Purdue and the Sacklers have. They're not just going to walk away and say, never mind, come and sue us. They're going to come up with another number and another structure that maybe isn't as advantageous for themselves, but that there could be some sort of resolution.
Is there an urgency in your mind to this? Like, there is always that, you know, speed versus depth. And is this a case that has to be resolved fairly quickly, or do you think that it's okay if it takes another few years to get it right?
Well, you know, the Purdue and some of those advocates on that side of the argument are saying, geez, we got to get this done fast because we have to get the money to the victims. We're actually in favor of it. And it's like, okay, well, we've been talking about this issue of non-debtor releases since you filed this bankruptcy. And we've been saying this is not a good tactic. There's constitutional issues. It's not statutory. Like, deal with this now before it has to be dealt with in 3 or 4 and 5 years. And, you know, you can't just cram a plan through based on faulty law and then get upset because there's no immediate conclusion. It's not like this is an issue that has sprung up late in the game. You know, it's been briefed out. Yeah.
Well, and to your point, there are many players in this game, and I'm curious about some of the analogs. I mean, if we're talking about, you know, alleged villains, we've had consultancies, we've had, you know, other drug distribution companies, you know, et cetera. Will this impact their liability in your mind? Because in essence, mentally, people almost felt like we'd moved on from the opioid crisis, that deal was done. Now we're focused on fentanyl and other challenges. Are there others who need to be held accountable, or do you think the Sackler family is unique?
First of all, this case has been reported on for 20 plus years. You know, I had a client named Ed Bish, whose son Eddie passed away in 2001, and he attended the first congressional hearings on Purdue Pharma. You know, this is a slow build, and, you know, everybody does lose patience, but over time, more and more information has been disclosed about what exactly is going on. So I don't think it's ending anytime soon. The McKinsey stuff, like you mentioned, the consultants, came up during the bankruptcy, you know, but they had been working on it. The issues we discovered were from 2014, 2015, you know, so they were already a few years old. I think that if you unveiled the whole process, you would see a lot of dirty hands in this because it went right from the manufacturers, the distributors, the providers, all the professionals that assisted them, all the consultants that assisted them, the insurance company, and then there are all these special interest groups that influence Congress. Richard Sackler famously said, I could get any congressman on the phone within 36 hours. Like this was a major structural issue. It was insipid throughout every body of government, every law firm. It's never ending.
Well, it is exhausting, I'm sure, and it's heartbreaking. This is a human tragedy first and foremost. And one of the things I'm thinking about is the money question. $6 billion was hailed as a victory because it felt like a lot of money in the context of the Sackler family and what on a monetary basis alone. Are those fines sufficient?
Well, they weren't fines; they were a settlement.
Or settlements. Forgive me. You're right. I misspoke.
Yeah. It would be nice if there were criminal fines against the Sacklers. There haven't been yet. But the way it's structured, there was a report filed in the bankruptcy during the confirmation process that showed that essentially the Sacklers wouldn't be losing any of their principal assets. Their payments that are structured to be made over 18 years would just basically be interest on the money that they already own. So they're certainly not losing any money that they've made off of selling opioids. They're just not, maybe gaining the interest that they would have otherwise had.
What is your message, Mike? And I know you're not, you're standing for some clients. I'm not going to make you obviously the voice of everybody, but are you hearing, from others who are involved in this case, there must be some who are disappointed that some of the money now may be slower in coming. What's your message to them? Or are you hearing that? Am I
Originally in the bankruptcy, there was supposed to be this emergency fund release of $500 million, way before there was ever a plan, way before there was ever a settled negotiation. That money never made it to help deal with the opioid crisis, and that was years ago. So money's been locked up for a very long time. We are sympathetic, and I am sympathetic to victims that would like, to get money to keep going. Like, we certainly understand that, and we're not downplaying that. But again, these issues were front and center from the very beginning, and it's something that debtors counsel, creditors committee counsel, PI counsel could have resolved within the plan, and they just chose not to.
Yeah. Has any of the money been released on a meaningful basis? I mean, I don't know if you are even aware of that. I'm not sure myself.
No, not from this case, no. But there are other, there's big opioid cases.
There's multiple opioid cases out there. So what's on your radar now that you would put on ours, as we're watching this case and trying to understand the implications of how it unfolds?
Well, certainly I would pay attention to the pressure that advocates and activists continue to place on the Department of Justice to seek accountability of the individuals. They really believe that people like Richard Sackler should be brought to charges. So I think that's something to pay attention to. And as that's running parallel, what happens in the Supreme Court? The makeup of the Supreme Court, it's a fairly conservative body, and it's very complicated because on one hand, there are a lot of the justices are originalists. They follow the letter to the letter of the law. They don't breathe in a lot of interpretation into the law. And if you read the bankruptcy scheme, it's very clear that there's nothing in there about non-debtor releases. But conservative justices tend to be pro-business. And so it's going to be a conflict for them and their clerks to decide how this case pans out. It pits some of their techniques along with business principles.